Hi friends, welcome back to the Legal Leader. In this today, we are going to discuss about the five writs of the Indian Constitution, which is very vital role in the court of law. That is why we are doing the video. And also as a law student, we should understand about the five writs, and as a citizen, we should know the about five writs because we are living in the civilized society. That is why, and as a citizen of India, we should know the Article 32 of the Constitution. Article 32 of the Constitution, as Ambedkar said, it is the heart and soul of the Constitution. Without this, we can't see the Constitution as a legally bound document. That is why Article 32 is a very important, which play the vital role in the Constitution. Today we're going to discuss about the five writs. What are the writs we can see in the Indian Constitution? Is type of writs is habeas corpus, mandamus, cessio, quo warrant, and prohibition. These are the writs exist in the Indian Constitution. Let's move on to the first writ of habeas corpus. The literal meaning of habeas corpus is to have a body, have the body. The object of this writ is to remove a person from unlawful detention or custody. Itself, this sentence states those who are illegally arrested from the police, they can sue the court of law, they can file the case against the police station, against the police officer if the arrested from illegally or unlawful detention. The court orders that person before into inquiry into a legitimacy of the detention. Before arresting, the police officer should give the warrant and relatable evidence. You are convicted this offense. That is why we are arresting. But if they fail to give those information to the accused, the habeas corpus is applicable. Then the competent of court orders the release a person in the custody if it is fined it arbitrarily. The court have a exclusive power to, if any arrested a person arbitrarily, the court have a power to release that person. The cardinal principle of this writ is the right to freedom, and the writ cannot be invoked if the order to arrest a person from competent of authority and seems under the jurisdiction. This is the main point, friends. Under the jurisdiction and prima facie legally. These grounds the police can arrest. But if the court found they arrested illegally, on the time habeas corpus is applicable. The writ can be issued against the public authorities and individuals, and the writ habeas corpus can be filed by the detained person and his family or friends. This is a relative example is recently the social reformer in the Ladakh who is arrested illegally. That is why his wife filed the case against the police station, against the police in the Supreme Court. This is the greatest example. Let's move on to the condition. There are three major conditions upon which this writ can be issued. The detained person is not presented before the magistrate within the 24 of the arrest. This is also main ground issuing a habeas corpus. The arrest was made under the unconstitutional law or unconstitutional laws. The person was arrested without any violation of the law. These are the main conditions we can be issues these scenarios in the habeas corpus. Let's move on to the mandamus. The literal meaning of mandamus is we command. The court issue is a form of the direction to the public authority to perform a particular task. It must be filled in the good faith by a person having a legal right. Those who are having a legal right, they should perform their work within the premises of the law. It can be issued against the government, public officials, inferior courts, tribunals, and public corporations. It is issued against the public authority denying performing its duty and has failed to do so, even though the public officer has failed their legal work. On that time also we can issue the mandamus. It cannot be issued against private individuals or president or governor or chief justice of India. We can't issue this writ against any private person like any individual. We can sue this writ as a legally sound point in the court of law is a public officials against the public officials or court and tribunals. Let's move on to the exceptions of the mandamus. Non-statutory department functions, it cannot be invoked in the matter where the duty is discretionary. Against the right to private nature, the direction will be controversial with the law. In the matter of the alternative remedy available, these are grounds is an exception called as an exception. Let's move on to the third writ of the cessio. It stands for to clarify. Its meaning is a to clarify. The writ can be used when the court finds the decision of the lower court erroneous and are beyond their jurisdiction. If the lower court use the beyond their jurisdiction, it can be used on that time. It used as a curative writ petition. The court has the authority to take a charge of the case by transferring it before itself and are quashing the verdict of the another inferior court. Before 1991, the writ was only allowed to be used against the judicial authority or quasi-judicial authority and not for the administrative. And after the 1991, it can be used against the administrative authorities as well. It can't be issued against the any private person or private people. Let's move on to the grounds of these articles. When the inferior court lacked the jurisdiction while giving a judgment, when the inferior court performed the beyond their judicial jurisdiction, and when the inferior court act against the procedural law, when the principles of natural justice is not performed by the court, these are the main grounds. Let's move on to the fourth writ of co-warrant. Co-warrant stand for the by what authority or warrant. It is used by the court to stop excessive use or abuse of authority. The court issues the writ to ask the public official to table his authority and holding that office, and court can suspend his authority. Means it's the sentence state itself state court can issue the writ when the public office or public officials fail to do their work or fail to their legal work. It can be issued against the private individuals also. Grounds. Let's move on to the what are the grounds we can issue this writ. A person has held a public official without authority. The person is unqualified under the Constitution of India to hold the office in permanent term, and it must be a public office. These are the grounds we can claim final writs of prohibition. It stands for to forbid. The writ aims to stop a judicially or quasi-judicial authority along with the tribunals from exceeding their authority. It works opposite to mandamus as it directs the authority to prohibit any activities. The higher court can issue this against the lower court. The objective to direct this inactive is to prevent the excessive application of one's jurisdiction. It cannot be invoked against the legislative bodies or administrative bodies and private individuals. Let's move on to the condition. Application of power beyond their jurisdiction, infringement of principles of natural justice using an invalid law. These are the main conditions. Using on that condition, we can sue the court in the court of law as a prohibition, as a legal bound topic or legal sounded point. Conducting in the conversation of basic legal rights, performed errors based on the records. These are the main grounds and conditions of prohibition. This is all about the three writs under the Article 32 of the Constitution. If you want to more legal updates, please subscribe this channel. And if you want to more legal newses, please connect with us, stay with us. Definitely, we will teach better law in this platform.